a Supreme Court case that could force emergency medical physicians to perform abortions. Renee Carlson of True North Legal is here today to tell us more about that case and her brief to the Supreme Court. That and more on the Family Beacon today. Thank you for joining us. Thank you guys so much for being here. I'm Moses Bradford of Minnesota Family Council. I'm joined by Renee Carlson, General Counsel of True North Legal, a public interest law firm dedicated to life, family, and religious freedom. You've heard from Renee before, but we're so excited whenever she is able to join us. Renee, you've been involved in several briefs to the United States Supreme Court. This is definitely one of the most important. Tell us more about this case.
Thank you, Moses. True North Legal has engaged in multiple briefs at the United States Supreme Court, of course, one of them being the Dobbs decision, Dobbs v. Jackson Women's Health. That decision came out in 2022, and that decision actually stated that states have the right to decide how their states are going to govern abortion. This case is called Idaho v. United States and actually comes on the heels of that decision. Idaho enacted the Defense of Life Act in 2020, and that law simply protects women, girls, and preborn children from the abortion industry by ensuring that doctors do not perform abortions unless it is necessary to save the life of the mother. Now, Idaho is very specific about what saving the life of the mother means. It certainly doesn't mean leaving women to die in an emergency room with no help if they have an ectopic pregnancy or if they have some other pregnancy complication. This means Idaho will care for women who, again, experience the miscarriages and other pregnancy complications. But all of these conditions, as we know, are not abortion. But the Biden administration then sued the state of Idaho, relying on a novel interpretation of a federal law called EMTALA. Now, this requires hospitals accepting Medicare funds to provide medical treatment to all ER patients, regardless of their ability to pay. And the reason why this law was enacted is because it was meant to prevent what's been known to some courts as patient dumping. So they're trying to avoid not caring for low-income patients. There's a threshold of care that's required that is stabilizing care under this federal law.
The law at issue here is called EMTALA. Can you tell us what that stands for?
Yes, it's the Emergency Medical Treatment and Active Labor Act. So essentially what we have here, Moses, is the Biden administration forcing emergency room doctors to violate state law by forcing them to participate in abortion. And we know that one of the biggest lies perpetuated by the abortion industry is that abortion is somehow the great rescuer, that women and girls even need abortion, and we know they don't. We know the consequences are actually life and death when it involves abortion. And that's why we engaged at this case. As we've said here at True North Legal and Minnesota Family Council, we are in it for the long haul, protecting life. And again, this ensures protections for women and preborn children. That's why True North Legal filed this brief at the United States Supreme Court. In fact, we represent 26 parties on that brief. MFC is one of those. Also, Kansas Family Values, another one of our partners here in the Family Policy Organization, as well as 24 other family policy organizations, including Family Policy Alliance. All of us are very invested in making sure that we not only have pro-life states, but a pro-life nation and a country that embraces life and that just ditches this culture of death that is perpetuated by the abortion industry.
I'm going to ask, this is a serious question, I'm going to ask that the Supreme Court really take a good look at the brief that Renee and these other organizations have submitted. So that's my plea to the SCOTUS. So amicus briefs focus on different topics. I know you chose one particular avenue of argument in this brief. Can you tell us more about that?
Absolutely. Well, as I shared, we filed a brief in support of Idaho, who enacted the Defense of Life Act in their state. And our brief specifically focuses on the statutory history of EMTALA, fleshing out what does EMTALA really mean? Why was it enacted? What is it supposed to do? So our brief discusses EMTALA's statutory history and its purpose, which of course we argue do not conflict with Idaho's Defense of Life Act, which is what the government is actually claiming here. Our brief is 26 pages, so needless to say, I'm not going to get into all of the details here, but I hope that our viewers can take home some high-level points about the history of EMTALA and be more informed about why this case is so important, and especially to be more informed in discussions about when the federal government tries to wield these novel legal theories to essentially quash and strike down state law through these crazy arguments in the courts. So what does the law say about EMTALA and what does it require? Well, as we're saying in our brief and arguing, EMTALA prevents emergency rooms from refusing care to any category of patients. EMTALA became law in 1986, and it wasn't a standalone piece of legislation. It was actually part of the Consolidated Omnibus Budget Reconciliation Act of 1985. But as we discussed in our brief, the House Judiciary Committee, prior to passing it, actually recognized, quote, a growing concern about the provision of adequate emergency room medical services to individuals who seek care, particularly indigent and uninsured, end quote. So again, this was designed to service a particular population who is in need. And Moses, the courts have interpreted EMTALA consistent with what we've argued in our brief. As the 11th Circuit has stated, quote, Congress enacted EMTALA in response to widely publicized reports of emergency care providers transferring indigent patients from one hospital to the next while the patient's emergency medical conditions worsened. EMTALA was designed specifically to address this important societal concern. Again, the courts have not referenced any of this abortion nonsense, and there's no implications in EMTALA that providing medical treatment means providing abortions. But the Biden administration is trying to broaden its scope and the enforcement by arguing that this treatment actually includes abortion. So the government basically is telling Idaho, your law doesn't matter. We're dictating emergency room care for your state and your doctors. They're stepping in to a very personal space. This is a state designated space. Right. And this is even for doctors to determine what kind of care on the spot in emergency room do I need to provide? This certainly runs afoul of states' rights, but it also undermines the practice of medicine. It's inconsistent with the doctors and the state's better judgment, and that's of significant concern.
So I think that's worth repeating. There is a federal law which requires that hospitals provide stabilizing care in emergency rooms. It was the Dobbs decision that allowed states to make their own abortion laws. Idaho chooses then to make its own abortion laws.
Mm-hmm. And the Defense of Life Act.
The Defense of Life Act. Then EMTALA, which does not mention abortion, which courts have never said that it requires abortions. But the Biden administration is taking an extremely novel approach and saying, oh, actually, it requires you to perform abortions, you emergency medical care providers.
Mm-hmm. And if the government gets to dictate what this care means or what these treatments are, what other treatments can it dictate? I mean, what other treatments can it impose on emergency rooms? Can it say that gender-affirming care is a necessary treatment? Is physician-assisted suicide a necessary treatment? What other novel ideas could they enforce? And that's even going to get into some controversial issues we have. Could they mandate, quote, conversion therapy in emergency rooms? Under this interpretation, that's widely opened, and that's a dangerous place to be in the law, and that should concern everybody.
And Renee, it seems like you're getting at how this might also be really concerning for conscience rights, where the Biden administration would force doctors with deeply held religious beliefs to perform abortions in emergency rooms.
Right. This novel interpretation does not speak to rights of conscience for any medical providers. And if, as the government argues, a procedure qualifies as a, quote, treatment under EMTALA and is required in emergency rooms with no exceptions for practitioners who object on moral, ethical, and religious grounds, they're going to be forced to do things that are completely adverse to their conscience, completely adverse to their protections under law. In fact, we note this in their brief that there are actually 44 states protecting conscience rights of providers who want to act and work consistent with their conscience and who do not want to participate in abortion. So our footnote in this brief is significantly important because it basically says, hey, if this is how you want to interpret the law, then there's 44 other states that might be engaged in litigation. And you know what? There's 24 other groups on this brief that are probably going to help that happen because we are serious about not only defending the rights of women and children, but of medical practitioners who are in this because they believe in life. They want to save life.
I'm so glad that you are sort of like standing the breach, making this argument, and that you and the other groups are not letting the Biden administration get away with this running roughshod over what sounds like a good federal law, but they're twisting it, and federal court precedent that they're twisting. How are amicus briefs important as the Supreme Court looks to make these decisions?
Well, we've seen an increase in the submission of amicus briefs over the last couple of years. I think they're significantly important because they either elaborate on a certain point in a brief and help expound and help give the justices more information to consider, or they come from a different angle. One particular thing that's been happening the last couple of years we're seeing as stories. People are actually getting to share sort of testimonies and humanizing these issues. So in this case, for example, there is a brief that where I believe over 2,000 women who are harmed by abortion submitted their thoughts and testimonies about how, again, abortion is not the great rescuer.
Wow.
We have physicians who are serious about their faith who have submitted amicus briefs, and we have policy groups like ours. We have national policy groups as well who have submitted briefs. We also have the state of Idaho, who is significantly, their policy group is significantly important in passing this, and they've submitted a brief along with our friends at Advancing American Freedom. So again, you get this wide variety of how the law is actually going to impact boots on the ground, real life. And I think that helps the court humanize these. So where they're, of course they're in the law and they're looking at precedent, but sometimes it's easy to get so sucked into the law and just the cases themselves that we can divorce ourselves from the real world impact that this has on everyone. And so I think that amicus briefs, bring to light all the other important angles. And of course, the law has become increasingly complex. So being able to flesh these things out in different briefs is significantly important, and especially for the parties that are litigating. And we hope that our brief discussing the history of EMTALA will be of significant help to the petitioners and to Idaho in this case.
That's wonderful to hear. I think I speak for everyone watching and listening, and of course for myself, when I just say, thank you, Renee. Thank you for going aggressively and getting involved in, even though there's plenty in Minnesota to keep you busy, and this case, of course, could affect Minnesota and affect the entire country, as you've said. And thank you for not just focusing on things that are right here in St. Paul, but looking at the national picture, looking ahead at things that might affect us, and aggressively getting involved and taking the lead on this brief. And then also thank you for coming here to talk about it and explaining that to us. And I know that there's plenty in Minnesota to keep you busy. Just the legal and policy environment here, as our listeners and viewers know, is keeping you busy. Is there anything regarding some of the other things that you're working on that you want to share with Minnesotans?
Well, we've certainly been involved in a lot of religious freedom issues lately with True North Legal. We've been involved in the St. Louis Park case where we're representing 6 Somali women who are simply asking to opt their children out of curriculum that is inconsistent with their religious beliefs, specifically curriculum that focuses on LGBTQ ideology. It's something that, again, is just very personal to them, and they believe that they have the control, as the law says, to be able to simply ask for alternative learning instruction, to ask for a different environment and just different materials, to focus on the same subjects, but not about the same content, which is LGBTQ gender ideology. Things seem to be changing every day. So we are continuing to monitor the activities of the school district and would love to come on and talk about what's next in that case, as there could be further developments. I'm also working with UMLC on a case where we are suing the Department of Corrections because they decided that a faith-based program called the Quest for Biblical Manhood is actually inconsistent with their DEI objectives. So again, another religious liberty case, and I could come on, and hopefully maybe James could come on with me and we could talk more about that case. Obviously, at the legislature, there's a lot of work being done. There was a significant hearing today about religious freedom, and so we've been monitoring that, and we'll continue to engage in that, as well as the ERA. We are watching and waiting. We've been educating legislators and educating the great citizens of Minnesota, letting them know that that is not your grandmother's ERA. That is not an amendment that has anything to do with equality. In fact, it is sanctioning inequality and subverting most every other class except for gender identity and those who want a constitutional right to abortion. So yes, Moses, a lot going on, but it's worth fighting for. As we've always said, again, we're in it for the long haul, and I am honored and happy to be here doing this alongside you and Rebecca Delahunt, who you had on here, and our other colleagues here at the Family Council and True North Legal.
Renee, thank you so much for being here. I think I speak for all of our listeners and viewers when I say how grateful we are that you are standing here in the breach, in this case and in so many others. You've talked about so many things today, not just the brief to the Supreme Court. And I often had the thought that if you weren't here, defending the rights of people of faith, defending families, defending the right to life, in some of these cases, that there wouldn't be anyone standing in that breach, that people of faith would be left out in the cold here in Minnesota without representation. So I and many other people are so grateful for your work.
Oh, thank you. Happy to be here.
Absolutely. And folks, if you want to find out more about Renee and her work at True North Legal, you can go to truenorthlegal.org. You can even confidentially request legal assistance there and make a donation if you feel led to support Renee's ministry. That's a tax-deductible donation. Now, speaking of other things that we have coming up here at Minnesota Family Council, I'm so excited about our annual dinner coming up on April 26th. We're having Seth Dillon, the CEO of the Babylon Bee. And the way that ticket sales are going, folks, you really need to register now. We are likely to sell out. And that means that it's possible that we'll even sell out before our early bird deadline on April 3rd. So register now so that you can get that lowest rate and make sure that you can get a seat at the Ruler's Rage God Laughs event on April 26th at the Doubletree in Bloomington. Shoot me an email if you want to inquire about special rates that we have for pastors. For the first time ever, pastors are able to bring their spouses. That's complimentary now. You don't have to purchase 2 tickets, just the one. And that deal is also for legislators. And we have special deals for guests under 30. And we know that many of our podcast listeners are under 30. So please join us again. Shoot me an email at moses@mfc.org if you have any questions about that event.
It's gonna be good.
It's gonna be good. I think it's gonna be funny, but also like in a godly way, not wasting our time with laughter, but showing us how godly laughter is just part of our calling as Christians and part of our joy.
And we need it.
And we need it. And that brings me to the final part of this podcast, where we always end with a verse from God's word. And Renee and everyone listening, that verse today is Isaiah 2:22. Stop trusting in man, who has but a breath in his nostrils. Of what account is he? And I think that's so crucial as we engage in this crucial work in the legal and policy arenas. It can feel that man has power, that these institutions have power over us and over our families. And there's a certain type of power that they have, but who has the real power? God alone. And so we who trust in him, there's an old poem, George Herbert. It's called "Our life is hid with Christ in God." So we are safely hid, under the shadow of his wings, his power, his glory, his might to save us, and his forgiveness of our sins. Those are the things that matter.
I like how it says, breathe it in, take a moment and stop, breathe and think who is in control. And I've had to do that a lot. Even I walked in today and I had to do that for about 10 minutes before this podcast. So it is an absolute real calling and ask of us to do that. And it's stabilizing and it's life-giving.
It does remind me of another verse, Psalm 118. What can man do to me? The Lord is for me, so I will have no fear. So I hope that's helpful to you guys watching, listening. And again, we're so grateful, Renee, that you were able to join us today.
Good to be here.
This is the Family Beacon podcast, where every week you can get the facts so that you can stand for truth. Thank you so much for joining us.